Welcome back, everyone, to OpenLine. We were talking with Barbara Boone McGinnis, elder law attorney. We were talking about wills. We've talked about estate planning for blended families. We've talked about all kinds of stuff when we talk about elder law. And we have some calls here. So let's go to Cornbread. Hello, Cornbread.
Yes, sir.
Go right ahead.
Will a handwritten will work?
Will a handwritten will work?
Yeah.
In the state of Tennessee, there is a provision, we call it a holographic will. So if it's in the testator's own handwriting, I would recommend dated, signed. It doesn't have to be notarized. But yeah, handwritten will can work in the state of Tennessee.
Is there any language they should use, like I, therefore, or could it just be I, whatever my name is, is there...
You want to make it look like you're intending it to be a will, not like a grocery list, right? You want to make it sure that it's looking like a testamentary instrument. So something about, I'm a resident of the state of Tennessee, I'm healthy and I'm of sound mind and I'm not under any duress or influence from anyone else, and at the time of my death I would like this to be done, and give it some sort of, and that gives it the intention. It's obvious to a reader that it's intended to be your will.
And a person that's doing that would know if there's a likelihood it could be challenged when they are gone.
Yeah.
And they should take that into consideration.
Well, and that's another thing, like storage of all of these documents, whether it's attorney drafted or handwritten, or something you've just created at home online through like Rocket Lawyer or something, How do you store them to make sure that they're safe and that they're going to be treated with the respect they deserve at your death, and they're not going to be somebody's cleaning up your house and go, oh look, Ben left a will. He didn't leave anything to me, and so that there's a way to know that it's been treated with respect.
All right, does that answer your question?
Well, see, I don't have nobody to I have no wife, no kids, It would be pretty simple, I think.
Okay, no wife, no children. Then if you still have parents, grandparents, brothers, sisters, any of those folks?
No.
Nieces, nephews?
So
Father still living? Yeah, but I don't want them to get nothing I got.
Well, so that's a good reason to have a will, because that's part of that intestate succession planning. Parents are in that tree. If you don't have spouse, you don't have children.
So yeah, he's saying he doesn't have anyone.
But he has a father that's still alive.
And so if he died without a will, the state would give it to the father. Is that right? That's just the way the things work. So if he doesn't want that to happen, he needs to have a will.
He does. And he's not obligated to leave, and no one's obligated to leave money to someone just because they're a relation. I mean, if
he can donate it to charity.
If you have charitable intent, you can.
Or give it to the person next door. He can do whatever he wants, right?
Yep.
That's very interesting. How often do you see fights over wills? How often does that happen?
Oh, it's very disconcerting when it does. And people that actually go to court to contest a will, maybe a couple times a year. Yeah.
And that is difficult, right?
That is difficult. And, we're not the attorney that's going to be representing someone in a contested will in court. We're going to recommend that to a specialist, because it happens enough that there are specialists, the people that do that.
Really? There are specialists. Yeah, that's tough when that starts happening. Okay, we'll take a break. Be back right after this.